Okay, I think we might have most people. Welcome and thank you very much for joining us for day 2 of the Wilberforce 2020 Cayman Conference. Welcome to those of you who are joining us for the first time, and welcome back to those of you who joined us yesterday. We're delighted to have so many of you from Cayman, London and further afield for the second of our 2020 webinars. We're going to begin with a talk today from Clare Stanley QC and Lexa Hilliard QC on future issues in insolvency litigation. We'll then move into separate Zoom rooms for a workshop, and we're going to end today with a virtual networking which will take place from this main Zoom room controlled by our marketing team. Just a few small housekeeping points before we start. Please keep yourself muted while Clare and Lexa are talking so that we can avoid background noise. When you're in the workshops, please do feel free to put on your video and unmute yourself. You can ask questions for Clare and Lexa through the chat function, and we'll deal with the questions at the end. Otherwise, at the end, feel free to turn on your video and ask your question yourself. And finally, we recommend that you view using the speaker view, so you can change that in the top right-hand corner of your screen rather than the gallery view. And I'm going to hand over now to Clare and Lexa.
Right, hello.
Hello.
This is Lexa and Clare's insolvency potpourri. We've been tasked to talk about future issues in insolvency. Lexa has written a long and very erudite paper, which will be circulated afterwards.
Claire did her bit as well. I mean, she's just making sure that I take all the blame for all the mistakes in it. That's what it is. That's what it's all about.
It wasn't actually, but there we go. It is very long and very erudite. We're going to speak for about 20 minutes, or that's when they're going to cut us off, about 3 areas which we think are ripe for consideration in Cayman. First, the clash between arbitration and insolvency. Secondly, legal professional privilege and its application to office holders. And thirdly, a couple of points on schemes. Arbitration comes up in a number of scenarios in the insolvency context. First, creditors winding up petitions when there's an arbitration clause underlying the debt. Secondly, just and equitable petitions where the background is a contract which has an arbitration agreement. And thirdly, and I think most interestingly, claims by and against companies after they've got into liquidation. And I'm going to kick off, and then Lex is going to teach me stuff that I don't really know about. I'm going to kick off with creditors winding up petitions. Now, everyone knows that a compulsory winding up order is almost automatically made on a winding up petition unless the debt is disputed. It's a summary judgment test. However, we've got this crazy decision in England called Salford Estates, which says where the debt is based on a contract which contains an arbitration clause, the company can avoid a winding up order if it simply doesn't admit the debt. There's no need for it to show that there's a bona fide dispute. It doesn't need to show that it's got an arguable dispute. It doesn't need to say there's a dispute at all. Just needs not to admit the debt. The company doesn't need to say, well, I want to go to arbitration rather than have this determined in the court. It just sort of sits there. There's this undisputed but not admitted debt, which can prevent the court from making a winding up order. I mean, I think it's completely bonkers, but that's the position in England. I would hope that the Cayman courts will apply a bit more common sense. What do you think, Lexa?
Well, I mean, you've seen the Singapore courts have kind of tried to kind of resile somewhat from the Salford Estates position, and with Salford Estates, the court said that it would only be in exceptional circumstances that the court wouldn't stay the petition in favour of arbitration, but the court couldn't think of any exceptional circumstances. At least in the Singapore courts have sort of come up with exceptional circumstances in this case called Annan, where the kind of circumstances that they thought would apply where the case would not be sent off for arbitration would be, for example, you know, if there was something about the company that needed to be investigated, clawback provisions, or if it was quite apparent that the dispute was not being raised on bona fide grounds in a way that was an abuse. So I think the Singapore courts are being a bit more sensible than the English courts. But okay, so I'm sorry, I kind of took Claire's thunder there, for which I apologise, Claire, because my bit that I'm supposed to be talking about is just and equitable winding up petitions, which we know that the Cayman Islands Court of Appeal has recently opined on, and in my view, because, well, you'll see in a minute, in my view, opined rightly, and it gives us hope in the context of creditors winding up petitions too. So just and equitable winding up petitions, I first was confronted with a just and equitable winding up petition with an arbitration clause years ago in 2003. And the case is called Magi Capital. We've got all the references in the paper, so you don't need to be frantically scribbling it down. But in that case, Magi Capital, LLP, it was an LLP with 4 partners who ran a hedge fund, all very colourful types. They all fell out. The major investor in the hedge fund had pulled out, so they practically had no business left at all. The operation of the LLP was absolutely deadlocked because none of them could agree with each other. 2 of the partners were going to try and expel the other, and then the other one turned around and tried to expel the other 2. And, you know, nothing was happening. So in order to try and sort of just bring things to a sort of sorry close, on behalf of my clients, who were 2 of the limited partners, we presented a just and equitable winding up petition on the basis that the business was just deadlocked. And then the other partner turned up and said, no, there's an arbitration clause between all the partners. It must go off to arbitration. And notwithstanding that it was just totally apparent that this LLP was just non-functioning, not carrying out any business, and couldn't carry out any business, the judge said, well, because, you know, both sets of partners are throwing mud at each other, it should all go off and be arbitrated. Meanwhile, the petition will be stayed, and then once the arbitrator has decided all the disputed questions of fact, the court can decide what to do, which I thought was very odd, because it's basically the court delegating its decision-making processes to some, you know, random arbitrator, which hadn't even been agreed on at the time. You know, 17 years ago, there was a very miffed Lexa Hilliard, you know, licking her, not licking her lips, licking her sores. And always felt that it was grossly unfair. But having said that, a few years later, there was the case of the Fulham Football Club, which was an unfair prejudice petition, which, lucky you don't have in the Cayman Islands, where basically the Court of Appeal, there was an arbitration clause there, and the Court of Appeal said exactly the same, namely that they're not going to determine the unfair prejudice petition, and the dispute should all go off to arbitration. So, and during the judgment, the Court of Appeal rather endorsed doing the same thing with a just and equitable winding up petition. So I knew then that...
Completely different, aren't they?
Yeah, I know.
Completely different. For a just and equitable petition, you just need to show sort of deadlock in your case, and that the affairs need to be investigated. Who's to blame is irrelevant. But in a 459, as they used to be called, 994 now, you do need to see who's to blame, and the underlying dispute does need to be resolved. I think it's wrong to elide the two jurisdictions.
I agree. So, but that is why both Clare and I are absolutely cock-a-hoop about the recent Court of Appeal decision in the Cayman Islands, where I have to say, sanity has returned. That's a case called Family Mart China Holding Company and Ting Quan, Cayman Islands Holding Corporation. Ended up being, a bust-up between two sets of shareholders of a holding company of what seems to be actually on that case a very, very successful kind of like small convenience store business, loads of them all over the PRC. And the argument, there was an arbitration clause in the shareholders agreement between these two shareholders, and of course the argument was that it should all go off to be arbitrated. And the Court of Appeal, in response to a just and equitable winding up petition, said no, we should keep it all here. Now, I think the judgment is very interesting, and one of the things is you get the feeling that the Court of Appeal doesn't quite like the idea of delegating their jurisdiction essentially to an arbitrator. But the one thing that sort of struck me when I read the decision was, unlike all the cases that have been going on in England, where it's always a London arbitration, with no doubt retired judges being the arbitrators, English judges being the arbitrators. In the Family Mart China Holding case, the seat of the arbitration was in Beijing, in the People's Republic of China. And I can't help thinking that that was perhaps an influential factor, bearing in mind that I think at least two of the judges had been commercial court judges in the UK. And I just think, if they'd been faced with the same thing in the UK with the London arbitration, I don't think the decision would have been the same.
Well, I think it's going to be really interesting if the Privy Council give permission relief to appeal, because the Privy Council is then going to have to confront these two really important issues. One, does arbitration automatically take precedence? But two, you've got to take the good with the bad, and if their perception of the good is that arbitration is a brilliant thing, then they have to apply that rule across the board, and so send these cases off to the PRC to be arbitrated, or Azerbaijan, or wherever. So I hope the Privy Council do give leave, just so that we can perhaps get a sense of reality back at least into English law, because as in England, I think the whole situation presently is bonkers. And going back to my Creditors petition, there's been a recent case, hasn't there, in the UK, Telnick, a decision of the Chancellor, Sir Geoffrey Voss. And in that case, apart from following Salford Estates, there was quite an interesting procedural issue in that case, because normally in a disputed debt petition, the petition is dismissed and the company gets on with its life. But in that case, the district judge at first instance stayed the petition pending the outcome of arbitration. And that seems to me to present all kinds of potential problems if the arbitration takes a while to deal with, because all post-petition debts are prima facie void without court approval. I just don't see a way through all of this nonsense.
No, agreed. So you're going to talk about post winding up now, aren't you?
Yeah, post winding up I think is really interesting, especially in Cayman. So you've got, I think there are two really interesting ways to deal with arbitration agreements. So if you're the liquidator and you want to arbitrate, of course you can, and you can force the contractual counterparty to arbitrate. But sometimes you want to be taking your own proceedings and not be forced into arbitrating. And I think that there are two sort of interesting routes which liquidators can rely on. First of all, there's Section 7 of the Arbitration Law, which in effect gives liquidators a right to disclaim contracts which contain arbitration clauses. And secondly, Section 97, and I only know a little bit about this because I've just done a case on it, but using Section 97 as a shield against claims by third parties against the company, saying, well, you can't sue the company without getting court leave, and we don't like that arbitration clause, and the court has power to override it because it has this incredibly wide jurisdiction under 97. And I think this is going to be really useful for clawback claims, for example, that liquidators want to make when they're then faced with this arbitration nightmare, which pervades.
There's those two Russian cases that we've had in the UK, where there's been Russian insolvency proceedings in Russia, and the Russian office holder have sought to proceed against former directors or sort of internal parties in relation to clawback claims under Russian insolvency law, and the defendants in Russia have trotted across to the UK and said, oh no, this dispute is subject to an arbitration clause with its seat in London. Please grant an anti-suit injunction. And hey, the English courts have done exactly what they've asked, because don't you know why? The seat of the arbitration has been in London. But I mean, it's a bit rich. Can you imagine if you had the same thing happening in England, where effectively you had a liquidator seeking to embark upon clawback claims against third parties, and then the third parties went off to the place where there was a seat of the arbitration and got an anti-suit injunction and slapped it on the liquidators here? I mean, it's just bizarre. But I mean, what's sauce for the goose should be sauce for the gander. So if a liquidator made an application to court here and said in the UK and said, well, what should I do? I've been served with this anti-suit injunction, and yet I want to pursue these clawback claims in the insolvency in England. I mean, really, the English judge should say, well, no, I think you'll have to go toddling off to, Kazakhstan and do your arbitration there. Very strange.
Yeah, and I mean, in England, it's a bit more complicated because we have obviously the Chancery Division where all of the insolvency stuff will be dealt with, and the judges will understand the need for there to be a single insolvency framework. But in the commercial court, where arbitration matters are automatically have to be determined, all of the judges are very pro-arbitration. But Cayman is, of course, different because the judges, they sit in the FSD, but they have this much wider range of cases coming before it. So I would hope that Cayman will lead the way, and hopefully England will eventually follow.
Yeah. So we're going to move on. We've spent far too long on arbitration, but it's a very interesting area. And we do address legal professional privilege and schemes in the paper in quite a lot of detail. So you can have regard to that. But looking at legal professional privilege very briefly, one of the cases that I had a sort of passing involvement in recently was in connection with the Bahama hotel development that went spectacularly bust in 2015, but was subsequently sold to an SPV with the major lender, or the lender actually, effectively putting up the money by way of credit bid. Anyway, it was an interesting case because what happened is that some sort of 3 or 4 years after the assets were sold, including certain claims against the builder of the hotel complex, what happened was that the receivers were informed that legal advice that had been obtained by the company before the company had gone into receivership, and which the receivers had shared with the SPV who'd acquired the claims as part of the assets that it acquired. The receivers were told about 3 years later, by the way, the shareholder claims joint privilege in those opinions. In addition to that, round about the same time, a member of the receivers team, who'd ceased to be a member of the team when he became a director of the SPV, for reasons that we don't really know, shared those opinions with the developer, the builder of the hotel, who was being sued by the shareholder in New York. Well, you can imagine a storm of biblical proportions ensued, and the judge in New York made some very pungent remarks about the receivers because she was led to believe, on purpose or unwittingly, that the receivers had been the individuals that had given the builder these opinions to which the shareholder claimed to have joint privilege in. And she required a transcript of the hearing before her. The receivers weren't party to the New York proceedings. I mean, they didn't want to be party to the New York proceedings, but the New York judge, Sally Ann Scarpula, who's since been raised to the Court of Appeal, insisted that the transcript of the hearing be sent to the judge in the Bahamas, Justice Winder. Nobody really knew what for, but the receivers thought, well, they better take out an application for directions of some sort. Fortunately, as the evidence came out, it became apparent that the receivers had certainly never authorised, either expressly or impliedly, this individual to give this legal opinion over to the builder. But I have to say, the hearing, which took place over 2 days and with experts on legal professional privilege on all sides, raised some interesting questions, and some of those questions are sort of set out in the paper. But in particular, I mean, what is the position of receivers and other office holders who disclose legal advice to a third party, believing that it's in the interests of the receivership, which is the test, but actually objectively it turns out not to be in the interests of the receivership? Are they in any way culpable, or is it the sort of test, you know, the sort of business judgment test that applies to directors? Is it a sort of, well, as long as they genuinely believed it was in the interests, that, you know, that's fine. And then who can complain about the misuse by receivers of legal opinions? I mean, in this particular case, the shareholder was saying, we have joint privilege to those opinions, but the shareholder wasn't prepared to make good that claim in the Bahamas. They were saying, no, we're going to make good that claim in New York against the builder, and we're not going to make it good against the receivers who were accusing of behaving improperly. So who can complain? Is it just somebody who has an economic interest in the receivership, or anybody? And then what steps should receivers or any other office holders take to protect legal professional privilege in advice that's been given to the receivership company prior to their appointment, but to which third parties might claim privilege, but you just don't know about it? I mean, are you required to just really anticipate that the privilege might not belong entirely to the company, or can you deal with it until you're told otherwise? So those are the kind of questions that are raised in the Bahamas proceedings. Whether we get answers to them, I don't know. I mean, I think as far as the receivers are concerned, as long as Justice Winder said you did nothing wrong, I think they'll go home and take a cold shower and live happily ever after.
Very large glass of rum.
Yes, exactly.
So we're running a bit over, but there are only 2 points on schemes, and I direct your attention to the paper when it comes. The first is what to do when, should you in a scheme include a provision which allows the scheme to be amended after court approval, and that raises all kinds of difficult issues which Lex has tried to grapple with in the paper. And the second point was really to draw your attention to a recent decision of Mr. Justice Snowden, who is Mr. Schemes in England, where a scheme which had been drafted by eminent restructuring professionals, put before the court by eminent leading counsel who does schemes all the time, Mr. Justice Snowden declined to sanction it. And very rare, but he was very critical of the scheme documents. And in Cayman, you have Justice Siegel, who is Mr. Schemes as well. So he will be very alive to this decision of Snowden. So we just thought we'd mention that as well.
Particularly as in that scheme, 87% in value of the creditors had approved the scheme, and there was only 30% in value who voted against it. But of course they were the ones, or some of them anyway, were the ones that sort of were saying that it shouldn't be sanctioned. And that's the problem. Once you have creditors that turn up and say, no, court, don't sanction this scheme, then it's often very, very difficult. If anything has gone wrong, it's very difficult to get it through. I understand that they're trying to promote a new scheme, but I think it's, I think they're having trouble there too.
So I think that brings us to the end of our potpourri. And I can see Liz coming back on, beautiful in pink. And I don't think we've seen any questions.
Well, if anyone's got any questions, you can pop up now and ask them. Otherwise, I wanted to know, what do you think, with your crystal ball, is going to be the impact of having likely a very large number of insolvency cases globally because of COVID? Do you think that having such a large number is going to flush out some lingering issues in insolvency that might have been hanging around for a few years?
Well, I think the scheme issue is something that needs to be pressed a bit, because at the moment schemes very rarely have internally within them provisions for radical amendment. We're living in very, very uncertain times. And the problem is, as the paper makes clear, that if you're, on the whole, if you need to radically amend a scheme, you need to go through the whole expensive rigmarole all over again. Whereas if you can have within the scheme itself provisions to amend the scheme by a statutory majority, for example, or not stat, but 75% in value, then theoretically, you won't have to go through the whole rigmarole again. The question is whether Mr. Justice Snowden or Mr. Justice so-and-so would wear it on a sanction application. But I feel that if you can justify it sufficiently, I think they should wear it, because we're living in uncertain times, and you can do a scheme, in 1 month, and things change dramatically so that you need to change the scheme in the next month. And there is authority for it, a case called Re-Cape, which we refer to in the paper. The problem with that is that the scheme was intended to last for 50 years, and it had provisions for its amendment, but the judge said it would only be a very, very exceptional case, and that one, of course, was because it was going to run for 50 years, where those kind of amendment provisions would be sanctioned in a scheme. But I think, you know, I think time has changed. And
would you think COVID might be the exceptional circumstance?
Yeah, exactly. Well, just because. And everything that may or may not run on from that. I mean, it depends really. I mean, if we suddenly get a vaccine and everything goes back to normal, then maybe not. But if we don't go back to normal, there's going to be, you know, we're in for a bumpy ride, as they say. And having an internal method within the scheme to be able to amend will be the equivalent to putting our seatbelts on.
Thank you. Well, I think if there are no other questions, what we're going to do now is break off into the workshops.